Hello, everybody. Maya's not here today. I'm running solo. We're for part two of the sex assault jury trials tips and tools session. Today, we're going to talk about the actual trial. We have some people here in the office, and when the rest of you are by Zoom, so thanks for zooming in. I'm going to go fast. I feel like I got a lot more to cover today than I did in the first one. And I provided here basically this is the talking points I'm going to intend to go throughout today's seminar. This will be made available to you as well. As we go through it, there will be some other documentation that I'll be providing to Maya to disseminate. One is it's like a sample cross-examination that I did in a case, and the other one is a more fulsome 3-4 page document on the closing address, because I don't think we're going to be able to cover all the details that I'd like to cover on those points today. So I want to start where do we begin when you're preparing for a jury trial in a sex assault case? I think the first thing you need to do is you need to sit down with your client and get your client's version of events. This is important, obviously, to decide how your defense is going to be mapped out. Is it a mistaken belief in consent? Is it a consent issue? Is it didn't happen issue? And you also want to get a sense of how your client presents, what his understandings or her understandings are of sexual assault, what they're allowed to do, what they're allowed to say, how they should present themselves. And I write here, ask personal questions. Sometimes it's difficult to get into these conversations with people, but I think you need to know about your client's sexual preferences. As you read the disclosure, what positions were, they engaged in, if any of this is relevant, because when you cross-examine, you're going to have to cross-examine the complainant on all these various details. Other traits that, like private physical traits, like there's cases that have come through both myself or other colleagues where, things like penis size is an issue, or tattoos, or private parts, things like that come in handy. You need to know this stuff. I know it's difficult and it's awkward conversations sometimes, but you need to get into those conversations, because I think those conversations are important because they help you develop your theory of the case, and it actually puts you in a position to have an understanding of what your client's version of events is, as well as what they intend to say and what the other person's going to say, because you're going to have to ask them those questions. I wrote here, be clinical. I mean, like, the client should feel like they're speaking to their doctor, not their lawyer. Sometimes it could be awkward to talk about these things, and you have to basically make them understand that. Sometimes I say that to them. I say, look, pretend like you're at your doctor's office. I need to know these details, and as embarrassing as they are, I need to know them, because this is, it's only your word against their word, and only the two of you were there. And so because it's only the two of you that are there, you need to give me this information. And they'll start opening up over time. I think that this is the type of conversation that you want to have early with your client, and then take detailed notes of those conversations, and then go back to them. And as your relationship develops with your client over the course of the litigation process, they tend to open up a little bit more, and you can ask questions that, hey, something I was thinking about last time, what were you wearing? What were they wearing? Were they wearing, what type of underwear were they wearing? What type of clothing did they have on? Were they wearing pajamas? Were they wearing jeans? If they were wearing jeans, what kind of jeans? Were they tight jeans? Like, all these little things are important, because it's those details that police rarely flesh out of the complainants when they provide their statements. And it's those details that start to make their story become impractical. Sometimes, we did a case out of our office earlier this year where, the way she described, the assault was, I was walking to the shower and he picked me up and he placed me on his penis. And, it was like, okay, that's all the police got out of her. They didn't get any details of that. What were you wearing? What was he wearing? Did he take off his clothes? Was he sitting there naked? Was he erect? Like, all these questions are important, because the police oftentimes don't flesh out those details as much as they should. And when you're cross-examining, you're going to want to hit all those points, because if you're in court and you watch experienced counsel who do a lot of sexual assault cases, for instance, I could just think of a few off the top of my head, like Francesca Yaskill or Jill Makepeace, Danielle Robitaille, very experienced counsel, do a lot of sex assault cases. they get into the nitty-gritties, and it's in those details that the devil comes out, as they say. And especially in a jury trial, because in a jury trial, when you're asking those detailed questions, you are teasing out, or you're tugging on those threads that the jurors are just using practical common sense, and they're saying to themselves, why? I don't understand. If she was wearing jeans, how did the jeans come off? Everybody knows if you're wearing tight jeans don't come off that easily. You have to, put some effort in to get them off. If they're loose jeans, or you want to ask some questions about that. How are they fastened? Is there a zipper? Are they button fly? I ask all those details because depending on those details, oh, they're a button fly. Okay, how many buttons? Oh, there's 5 buttons. How did you unbutton them? Did they pull? Did they rip? Did your clothes rip? Like, all these things start to come out. And then ultimately your question's always going to be, you didn't mention any of this to the police. And they're going to turn around and say, well, they didn't ask me these questions, which is a fair answer, but it seems, a little bit improbable that you're coming here now 2 years later and you're providing all these details that you never provided before, simply because the police didn't ask that question. So that's why you need to get those details, and you need to get as many as you can from your client. And then you can use the information that you get from your client in preparing your cross-examination, especially with physical descriptions, if there's any, BDSM or any type of any type of fantasy, dressing up, any of this stuff is all relevant. So you want to know as much as you can about your client and about his version of events and how this all unfolded, because you're going to need to do that. And we'll get to the Brown and Dunn aspect of it later, but it also helps you in crafting how you're going to present your defense and what defense you're going to be putting forward. Now we're going to talk about the preparation of the cross-examinations. I like to map out my cross-examinations. I like to, like if you read any of the classic cross-examination books, Posner and Dodd, or Earl Levy's book, or, any of those books, they'll tell you, come up with themes and cross-examine to themes. It depends. There could be some overlap, but, some of the things to consider, and then this is not an exhausted list here, is, motive to fabricate, inconsistencies, implausibilities, Brown and Dunn, and then you have your 270 and your 276 items that if you've brought in those applications as well. So when we get into each one of them, you want to be able to tell your story through these themes and how they come about. I didn't list them in any specific order. I just listed things as they came to my head. But the motive to fabricate is always a good one if you have one. Maybe it's a bad divorce. Maybe it's a bad breakup, right? So you might want to get there first just to lay a foundation for the jury, because oftentimes the Crown doesn't go there, right? They leave that. So you get there, you're going through a bad breakup, and then you can circle back to it at the end of your cross once you've developed inconsistencies, once you developed improbabilities, once you've had an opportunity to put your client's versions of events to them, once you've challenged them with the 278, 276 materials, you can come back and say, and it's for all these reasons, ma'am, that you've come here and you've lied about what occurred. It's for all these reasons that these are the reasons. And, you had this motive, you had a bad breakup, you had a bad divorce. And as a result, your story doesn't make sense. Your story is incredible, and other items. So map it out. How's it going to go, and how's your story going to be told? You don't have to be religious. You don't have to stick to it, that roadmap specifically, but you need to know that we want to get to all of these points throughout the cross-examination. And of course, there are going to be overlaps. And so you'll see in my sample cross-examination I provide to you, I write it out in a question and answer form. But I don't necessarily, I don't stick to that form exactly. I'll take an opportunity to jump around if the witness gives me that opportunity to jump around. But the reason why I write it that way, you'll notice when you see it, is that I pinpoint the prior statements. For instance, if you have family court affidavits, or you have text messages, or you have prior statements, I use the language that the witness used in those other documents in formulating my questions, so that my questions are precise and there's little room for explanation, like for ambiguity. If you don't do it that way, and you paraphrase it, or you change it into a language that's more familiar to you, what you're actually doing is you could be leaving it open for the Crown or the witness to explain, well, no, the way you asked it wasn't what I meant. I meant this, and that's what I said. So if you use the words that they use in their statements, then the words are there. It's the exact wording, and it's much easier to get them to agree or adopt that wording, or it's much easier to challenge their explanation. So when you said, your shirt was a halter top, those were the words you used. Now you're describing a tube top, not a halter top, right? And you agree with me that those are two different types of tops, right? You never made that opportunity to explain. So if you use the word halter in your statement, and they decide to back away from it now in some way, you have that wording, and it's for the jury to ultimately decide what they can make of those sorts of inconsistencies. So that's why I like to use the precise wording that they use in their statements. Now, I want to move on. I'm going to get back to the 278, 276 stuff, Brown and Dunn stuff, but I want to move to the organizing of your exhibits. This is becoming more and more important. I recommend that you use technology. Make sure at the outset of your trial that your computer connects to the courtroom equipment. That's important because oftentimes it doesn't. And if there are any issues with your computer connecting to courtroom equipment, you raise it with the judge and make sure that that issue is fixed as soon as possible, and make sure that it's fixed before you cross-examine. This is particularly important when you're dealing with 278 materials, when you're dealing with 276 material. And I'll tell you why. Because if you have 4,000 text messages that you want to that you're entitled to use, you're not going to necessarily cross-examine the complaint on all 4,000 messages. So what I recommend you do is you use technology, the technology to crop or highlight the relevant text messages or the relevant portions of the statement and blur out or black out the irrelevant stuff. And then you can present it on the screen. Because the last thing you want is the witness to, for instance, if there's 30 messages showing up on the screen and you're pointing to number 15, which is right in the middle, the last thing you want, is to have any prejudicial information from all the other messages to be shown to the jury. B, you don't want the witness to have an opportunity to see those other messages from perhaps different dates and times and spout out some other prejudicial stuff, or try to use those to provide an explanation to what you are ultimately questioning about. If you're not going to take anything out of context, because you know that if you take something out of context, that's going to be objected to, and the Crown's going to have an opportunity to fix that, and it's going to hurt your credibility. But if you have an opportunity to pluck out a text messages that stand alone, or like there's 2 or 3 that provides a conversation, and let's say the 15 before and the 15 after are not relevant, black them out. Black them out when you put them on the screen, so that the focus, both the jury's focus and the witness's focus, is on these messages. And when you have those items blacked out, you screen capture them, they're blacked out, you put them on the screen, you create your exhibits, you tell the judge, at the end of my examination, I'll make this one the next exhibit, and then you just mark it as an exhibit in your file, in your digital file. And at the end, you provide them to the registrar, either by way of a USB or by email, so that the registrar can then create an exhibit for all of them. And this is really, really important. And it's something that, we've had experience in recent years. Earlier this year in a trial where the technology from our computers didn't work. All the preparation was out the window as a result. We had to use stock computers provided to us by the staff, and we had to rely on the original disclosure. The original disclosure was then downloaded onto that computer so that it would run, because it wasn't running off the Mac computers. And ultimately, the registrar then inadvertently provided that same computer with all the disclosure to the jury in the jury room. And the jury then came back saying, well, we have all this information on this computer that wasn't part of the trial. We moved for a mistrial. It was denied. But that's like an extreme example of what can happen when, we take for granted that technology is just going to work. Right. But what else happened in that case was the witness was wise the first time you might have got her on a text message, the second time you might have, but by the third time she started to look at other messages and not just the ones that you were pointing at. And then she started saying, yeah, but see, in this message here, he called me a slut. In this message here, he called me a bitch. And then all of a sudden, there was all this prejudicial stuff that started coming out simply because we couldn't use the technology that we'd prepared in the way we wanted to cross-examine. And it was significant prejudice to our client. So I really, really recommend using this. And this is not, you don't have to be tech savvy to use this. This is our everyday computer software. PDF, any PDF reader allows you to, black things out, screen captures. This is easy stuff. Just have them all lined up, create file folders with the exhibits so that you can put them up one by one, and so that you have the control over the cross when you're putting this information to them. With respect to the 276 materials, you really, really need to know the rulings and know what you're allowed to ask and what you're not allowed to ask about. This is critical because obviously, with the 276 items, there's always this concern that you're going to cross into some myth-based arguments or some myth-based questions. And what the Crowns are doing now as a tactical move is they're preemptively objecting to questions. And I'll get into this a little bit later, but they preemptively object to questions on the basis that they think you're going to get into some myth-based reasoning. And so what they'll preemptively object and say, Your Honor, I have some concerns, and the jury will leave. It'll screw up your flow, and they'll say, well, I'm concerned that my friend's going to get into myth-based reasoning here with this line of questioning. Obviously, the line of questioning is not necessarily itself something that's going to be in myth-based reasoning, because we are trained not to engage in that reasoning. And you're not sitting there preparing a defense saying, I'm going to make her less worthy of belief because, and apply these myths. You're not going to do that. Like, it's not something that you are prepared to do or you're planning to do. So always know the ruling and know why you're asking those questions, because obviously if you were permitted to ask those questions, you've already convinced the judge as to why you're allowed to ask those questions, and always have that fallback position. When we talk about the execution of the cross, we'll talk about phraseology, but you have to know what those rulings say, and you have to be very, very careful not to cross over any lines within those rulings. You may be allowed to ask some things and not others. So be very, very mindful. If you cross over, you could risk a mid-trial instruction. You could risk a mistrial, and you don't want to do that, especially in a sex assault case, because you want your first shot to be your best shot in your cross-examination. Using prior transcripts. First step, I say, is have all the transcripts transcribed for cross-examination purposes. My first step is always to just request it from the Crown as a matter of course, see what they say. If they agree and provide it to you, bonus. I always try to review the transcript against the video, because sometimes the transcripts are not accurate, or sometimes there's a lot of inaudibles. If the witness has an accent or speaking a different language, the transcriptionists can't really understand it. Oftentimes those transcriptionists are just police people. They're not like professional court transcriptionists. So the accuracy of those police statement transcripts are always, in my opinion, questionable. So listen to it yourself. And if there's any issue, or you feel that something's not accurate, raise it with the Crown. And if the Crown disputes it with you, then bring an application to the judge to have a judge rule on it. And, there's something in jury trials, I always say, don't complain about something unless you want a remedy. Don't complain unless you want a remedy. I mean, that should be your motto as in all litigation, but particularly in superior court in front of a jury, your remedy has to be, it's unfair to my clients, unfair to my client. My client's not going to have a fair trial. So if your client's not going to have a fair trial, he's not going to have a fair trial because of this. You want a remedy. Your remedy is X. Your remedy is Y. In some cases, your remedy is the judge can make a ruling as to what can be heard on the transcript at this given point in time. And if there's any dispute about it, the judge will have to decide how to remedy that dispute. If you want to use the video itself, because sometimes the video is helpful, if the person appears incredible in the video, or if they don't appear to be taking, their statement to the police seriously, that's fine. You can do that. just be prepared to do that. Again, use the technology to your advantage. Make sure it plays on your computer. Make sure it plays in open court. Make sure you have your timestamps perfectly set up, so that you can go to those timestamps, so that you can hit those timestamps in front of the jury, hit play, hit stop. Make sure that you have the transcript references available for the judge as well as the Crown, so that they can follow along with the transcript as to the portions that you're playing. All of this is important because the more prepared you are in front of a jury, the more credibility you have, the better your presentation of the case is going to be, and the jury is going to be looking at you as the lawyer who is the person that they should be listening to, because obviously they know the case, and look how well prepared they are by the work that they've done in preparation. So get to those things and put the time in at the front end to make sure that those things are done properly. Judges are now requiring witnesses to have copies of transcripts when you cross-examine them. I hate this. I think it's not necessarily fair. I think the old school way to do it was just to read question and answer from the transcript. But the problem, as I see it, is twofold. One, I think a lot of lawyers are not properly putting transcripts to witnesses, and so are creating a lot of error, or a lot of opportunity for error or inaccuracies when they do it. And two, a lot of judges, with no disrespect, but a lot of judges maybe don't have that amount of trial litigation experience that one would think that they have to know how it's to be done properly. You know, in the old school way, you would never give a transcript to a witness. The Crown would give the transcript to the witness, ask them to read it, ask them to refresh their memory, and then ask them questions about it if they're permitted to refresh their memory with the transcript. In cross-examination, you never had to do that before. If you read it, you know, if you read Earl Levy's book on cross-examination, which, you know, is maybe an older school book, the way it would be is you say to the witness, you know, in your statement to the police, you said you were wearing a blue shirt. No, I never said that. Okay, ma'am, I'm going to read the following questions and answers. And then you say, to the benefit of the court and the Crown Attorney, I'm starting at page 19 on line 20. Question: what color was your shirt? Answer: my color was, the shirt was blue. But did it have any markings on it? No, it did not have any markings. Were you wearing any other color shirt? No, I was not wearing any color shirt. Then you say, ma'am, do you recall being asked those questions and giving those answers? Yes. You were under oath when you provided that statement to me? Yes. Was it true then? Yes. It's still the truth, right? You were wearing a blue shirt, right? So when you testified here that you're wearing a red shirt, that's not true, is it? You're actually wearing a blue shirt. That's how you would do it in the old days. And that's how I like to still do it, because I don't want the witness, because then the witness is going to look at page 19, and then the witness is going to see that at the top of the page, oh, my client called her a bitch. And then she's going to say, yeah, maybe I was wearing a blue shirt, but I was all frazzled because I just told the police that he called me a bitch. Well, I didn't want that to get in front of the jury. So I don't want the witness to have that control over that entire piece of evidence. So I limited to what I want to put up there. And I've gotten into arguments with judges. And so I've resorted to what I wrote here, which is crop it and do the exact same thing and be able to just put it on the screen, the portion that you think is relevant. And it's not for the witness to determine whether or not the statement's been taken out of context. That's why the Crown Attorney's there. And that's why the judge is asking for a copy of the transcripts, to also police that. So if you're going to take a particular line or two or question out of context, this is an adversarial process where the Crown is responsible to guard against that. Right. And so is the judge. And I've gone to that type of argument with the judge, and I've said, look, this is not the responsibility of the witness. The Crown can, if I'm doing something wrong, I expect the Crown to object. And if the Crown doesn't object, that means I'm not doing anything wrong. And if Your Honor has a copy of the transcript, you can see that I'm not doing anything wrong. But I don't think it's fair that the witness has this transcript, because it runs the risk of the witness going off the rails and talking about other stuff that's on the page that's not relevant to my examination. So you have to be forceful on this and structure it the way you want to do it. But it's also, there's been cases when all of a sudden I feel like I'm instructing the trial judge on how a cross-examination should be conducted. This is how I want it conducted. It's my cross-examination, and I don't want to give a copy of the transcript to the witness. I want to read the questions and read the answers. And if you want, I'll put it up on the screen, limited to the portions that I want. And and then, you know what, if he says fine and go that route, then I'm saying I need a break to do that, and I'll have all my things queued up. You know, and you got to be a little bit forceful, because you want that control just in case. Because any chance they get, and especially if you start impeaching witnesses a lot, then they start going off the rails on what they want to say, and then they start saying negative things that could prejudice your case. Now, Sam Pachala came here, asked me a question last week. I didn't answer it, but I wrote it down here as best as I could so that I can answer it here today on this specific point. And her question was basically the difference between effectively using transcripts and cross-examinations in a jury trial versus in a judge alone trial. There's three things that came to mind: impeaching witness on a prior inconsistent statement, when a witness said something new at the trial that she has never said or he has never said before in a statement, and when a witness that says something that is refuted by independent evidence by other witnesses. So on the first one, the impeaching, as the example that I just gave you about the blue shirt, I mean, that's pretty much the way the cross-examination goes. There's a prior inconsistent statement. I ask them to adopt the prior inconsistent statement, and I suggest to them that their testimony in court is inaccurate, or vice versa. If I want the statement in court to be more accurate, because a red top is better for my case than a blue top, then I ask them, to adopt the prior statement and suggest to them that they're wrong here in court, or sorry, the other way around. I suggest them that, their memory was better at the time and that the blue top was what they were wearing, so on, and get them to adopt that. Both are fine. One is to prove that they're lying here in court or they're inaccurate here in court. The other one is proving that there are competing statements. They've said the same thing. They've said given different information about the same thing twice, and it's for the jury to decide how they want to weigh that. But that obviously goes to their reliability. When a witness says something new that they've never said before, this is a little bit tricky, because, for instance, if they've provided a 100-page statement to the police and they never mentioned in the statement to the police that your client forced oral sex on them, which is like a pretty aggravating fact that was never mentioned to the police, and they say, and you say to them, well, ma'am, you agree with me that you've never said this to the police in your statement. And they say, well, I don't know. I'd have to review the entire statement to remember that, because that's what they try to say to be clever, right? My first answer to them is, well, the Crown Attorney's here. The Crown Attorney, if I'm suggesting something that's not true, the Crown would object, because I'm not allowed to do that. So I didn't hear an objection from the Crown. So you could take me on my word that you never mentioned this to the police. Oh, I don't know. Okay, fine, if you say that, but I'd be more comfortable to review the statement. So now, and then I might say something like, perhaps it's a 100-page statement. Perhaps we could do it at the break. I don't want to waste the jury's time. So now all of a sudden, the jury's thinking, okay, this woman's, or this complainant, this man, whoever it is giving us a hard time. So you do that. When the break time comes, you say to the Crown, what do you want to do with this? Do you want to take a break so that she can read the 100 pages, or are you just going to give me an ASF that this was never said in the statement? The Crown oftentimes will just say, no, I'll just give you the agreed statement of fact, and that's it. Because obviously the Crown didn't object. You didn't do anything wrong. So you could just get an agreed statement of fact after the witness is done, saying the witness never said in her statement that this thing about oral sex. Done. And it's the same thing if they agree that they never said it in their prior statement, but it's something that came to them now. The cross-examination in front of the jury is this: well, before you testified, ma'am, you had an opportunity to review your statement, right? Officer Smith was here. She's a lovely officer, senior officer. She sat with you while you watched your statement. There was a victim witness assistance person in the room. They were all there, and you had a chance to review it. You didn't mention to any of them that there was details in that statement that were missing, did you? No. Well, they would have asked you, and oftentimes you can get notes from the police officer about that meeting if the police officer is involved. And so you can ask them, the officer gave you every opportunity to add. Is there anything you wanted to add? No, there's not. Then my friend here was asking you questions again when she was examining you in chief, or he was examining you in chief. And at that point in time, you didn't add that detail either. But now when I'm cross-examining you for the first time, you add this detail. So, you get them to adopt that they've just watched their statement. They never mentioned this inconsistency. They never mentioned this detail. They never mentioned it in chief. They're mentioning it now in cross. And it basically, builds you like you have nothing against the police. You have nothing against these other people. You have nothing against the Crown. Everybody's doing their job. Obviously, it's obvious that a major detail wouldn't be forgotten. And if they give you an answer like, well, I didn't know I could add new things. I thought I had to stay with that. Then you go to the oath and you say, well, you're here to tell the truth, right? Yes. And in part, they ask you, are you prepared to tell the whole truth? You understand that? It's not something that's just limited to what you said to the police. It's the entire truth. So if there's something new, you're going to tell it, right? I'm just wondering why it only came to your mind now and not before. When you exercise the cross-examination like that in front of the jury doesn't see you as bullying or beating up this complainant. They just see you as using logic and common sense as to why they would just add this very important detail now and never added before. And it's in the context of the whole truth. These are the types of examinations where, in a judge alone trial, they may or may not land well. Some judges don't like you referring to the oath at all. But in the front of a jury, no one's going to object. You do it in a gentle capacity. It's the wording that you're allowed to use, and you just use it. The third thing is when a witness said something that is completely refuted by independent evidence or other witnesses. So I like to do this. Some people don't like to do this, but if you had a witness testify, the first witness, let's say it's an officer in charge who provides, or let's say it's an independent witness, a bar owner says, yeah, I saw them chatting at the bar. They were talking before they left. And then the complainant comes and says, no, I only talked to him for the first time outside of the bar when I was walking to my car. I say to the witness, well, we heard from John Smith. He's the owner of the bar. He testified here that he saw you talking to my client inside the bar, having a drink and laughing. Do you agree that happened? Is that possible? Or is it your position that he's completely wrong about that? And all of a sudden that witness is saying, oh my God, there's somebody else saying something different than what I'm saying. And you can do that to a certain extent. You don't want to get too carried away in it. The purpose of it is you're putting it there to get the reaction and get the answer from the witness in front of the jury to see what they're saying, right? And if they turn around and say, well, that guy, I don't know who that is, but he must be totally wrong because that never happened. When you go to the jury, ultimately at the end of the day, you say, well, John Smith has he has no stake in the game here. John Smith is just a witness. He's a good citizen coming forward to help. Meanwhile, we have a complainant here who is completely, has a motive to fabricate. She has a stake in the game. Who are you going to believe? You're going to believe this innocent person who just came forward to help, who made these observations and has called the police, or you're going to believe her. That's how you do it with the independent witness. And if there's independent evidence, you take the same approach as I suggested before, which is you ask the Crown at the break, listen, can we get an agreed statement of fact that the police seized a blue top, the police checked for DNA and there was no DNA found, et cetera, whatever it is, whatever the independent evidence is. And what you might say in your cross-examination is, I expect that we're going to hear evidence in the trial that your clothing was tested for DNA, specifically semen, and the experts that tested it found nothing of the kind, ma'am. You didn't wash these clothes. You say the semen was there. You provided to the police, et cetera, right? And even if that evidence, if the Crown's not planning to call it or whatever, you can suggest that in that way. And then it might be your burden to call that evidence or put it in some way in an agreed statement of fact. But the Crowns don't usually give you a hard time about evidence that is that type of concrete independent evidence that came up as part of their case, because realistically you could put it in through any witness, any police witness. Sorry, I'm gonna have to pick up the pace. Sam's question was a little complicated, but I'm gonna move on. Be ready for mid-trial 278 applications and don't be afraid to bring them if necessary. But I recommend that if you're going to bring a mid-trial 278, you have to bring it because you've developed something through the cross-examination that only permits the 278 now. It's not something that you could keep in your pocket that you could have brought before trial and tactically decided to bring it now because the judge is not going to be happy with that. But for instance, if you're cross-examining a complainant and you're putting to them certain questions that are getting complete denials, and those questions are as a result of some Brown and Dunn information that you have from your client, you need the denials in order to potentially give the relevance to the 278 material. In a recent case I did, that was a video. I had a video of the complainant completely assaulting my client, but she never said in her statement one way or the other that she ever assaulted my client. So I had to cross-examine her on whether or not she assaulted my client. And it was in the face of those denials that I had now what I believe to be grounds to admit this video to confront her about the assault that she conducted on my client, because there's a video of her assaulting my client. Now, in any other trial, I would need a 278 application. In the sex assault trial, I would need a mid-trial 278 application. It kind of fell under the radar. Nobody objected, so I just did it, and that was the end of it. But I was prepared to bring a mid-trial 278 application because I really needed this evidence in, because this is the exact type of evidence that goes to undermine her credibility on this very important point. The relevance of it only came to light in the face of her denials. If she testified that she assaulted my client on several other occasions, that video may have not been relevant. I might not have gone down that road. Let's go to number 3, the execution of the cross-examination. Brown and Dunn, make sure you cover your client's versions of events. That's important. Get the denials from the complainant. And I recommend you don't like, so what I suggest here is phraseology matters. You word your questions. If Mr. Smith were to testify that you removed your own underwear, would you agree with that? As opposed to what crowds typically do is, I'm going to suggest to you that. Once you start your question with, I'm going to suggest to you that, they're going to automatically say no, right? But you might want an answer that person might say, well, no, I mean, I did remove my own underwear, but, and all of a sudden they give you that but, and then that but provides you an opening. Because if that is true, then she's providing corroborating information of your client's version of events, which is important, that she might have never provided before. He might have never provided before. So be aware of how you phrase your questions in putting your client's version of events. If you just want the denial, then you just start with the, I'm going to suggest to you that. But if you just ask a question, madam, it was you who engaged willingly in oral sex. Do you agree? You might go that route. Or if my client were to testify in this case and he says this, and this, what would you say to that? Oh, he's completely lying. That's not true. That's what you like. You do it in that way because you want the jury to hear, oh, we're expecting Mr. Smith to testify. We're expecting to hear these things. On the twin myth reasoning, be ready for the Crown tactical objections. Okay. And always remember, they are not in your mind. You're not advancing a twin myth argument. Under no circumstances. The simplest example is late reporting. Your cross-examination starts, well, ma'am, you agreed with me that this happened on March 9th, and you didn't go to the police until March 28th. Objection, Your Honor. I ask the jury to be excused. Your Honor, my friend's going down a path that I would submit is, engages myths and stereotypes of how a complainant would report a sexual assault. We know, and the courts have said this repeatedly, that sexual assault complainants may not report right away. They may, and they go on their little tangents about that's all tactical just to throw you off your cross. The answer to that is, it's her answer that matters to me. She might say, yeah, I didn't report it for 2 weeks because he was still paying my rent and I wanted him to continue paying my rent. And then once he was done paying my rent, he decided to stop paying my rent. Then I decided to report it. Well, I want that answer. That's not a sexual assault complaint and having difficulty coming forward. That's somebody who's using this to their advantage as long as they can, and then deciding to report it. That changes the dynamic. If her answer is more akin to what, this was really hard for me, and it wasn't until I went to therapy that I started to discuss this and learn about this and realize something was wrong, that might open up another can of worms. Have to bring another application. You might have to get some more information about that. But the Crowns are preemptively objecting, and it is a tactical move. And I've spoken to Crowns about this. It is a tactical move, and they're jumping on counsel's phraseology and how they're asking those questions. Don't be afraid. I know they say, well, no, cross-examination is close-ended all the time. Don't be afraid to ask an open-ended question when it comes to stuff like this, right? Why is it that you didn't report this for a month and a half? After you've built that the relationship continued, after you built that, things were going well, after you maybe laid a foundation for what happened just prior to the reporting, because you want the explanation. You want that explanation. And it's unlikely that the complainant, he might provide a myth-based answer. I might say, this has been, it's difficult. It's not something I was happy or something I was, something I found difficult to do. And then you might not be able to go to the jury with it. But you can always ask, well, how come you never told that to the police in your statement? How come you never told it to the police that it took you 6 weeks to come forward because of this? Right? Because that might open up another can of worms, as I said, right? So you want to be able to ask those questions. You just got to be very particular with how you ask them. Asking them in an open-ended fashion, not accusatory, right? If there's 278 material, if it's a mistaken belief in consent, the fact that if they're engaged in some kind of, kink or some type of BDSM sex stuff, if you're trying to use that in an accusatory fashion to suggest that they're less worthy of belief because they engage in that type of behavior, you're going to run into an issue, right? But if you keep it open-ended on that sort of stuff, you're going to get the answers you want, because unless it's really true that their answers are really true, the more likely answer you're going to get is some explanation as to why they didn't come forward sooner, or why they engaged in this behavior doesn't matter. You're going to get the truth out of them, even if it's an open-ended question. It's only that question has to be open-ended. Then you can take that answer and start to break it down a bit more and cross-examine a little bit further on it, and be ready for the Crown's objections if they come. But always know and feel confident in the knowledge that you are not engaging in that reasoning, because frankly, it's not effective. I know the Supreme Court, when they were arguing JJ, and, some judges from the Supreme Court were saying, it still happens every day. Women are being accused, the complainants are being accused of not being worthy of belief because of this. Yes, it might happen every day, but we are doing the law is really preventing us from getting there, and we as a bar, I think, are doing a good job to avoid that. We don't want to go down that route, because frankly, it sounds ridiculous. You're not going to go to the jury and say, well, she had sex with 6 partners in her life, so therefore she's more likely to have consented today. You're not going to do that, right? Like, or she's less worthy of belief because of her sexual history. Like, you're just not going to do that. It's just not something that you're thinking about. So don't let other people put you on the defensive to suggest that that's where you're going, because you're not going there. The 278 application. If the complainant is made aware, which they are, that you're going to ask about, let's say, something that came out of the 278 particular text messages, and they have a nice prepared, ripe answer, but the rest of their testimony is a little bit off, I'm not afraid to ask, and I don't think you should be afraid to ask, well, ma'am, you were prepared. You knew I was going to ask you questions about these specific text messages, right? And she's going to say yes. And you say, well, because the law requires me to give you notice that I'm going to ask you about these questions, right? So you had an answer prepared for these questions. A lot of people are afraid to do that. I don't think it's offside at all. And it gives the jury an understanding that, well, why was that answer so prepared and so tight? Well, it was because she was prepared for it, because the law requires us to give them notice of that question. And it's something that you can go to the jury and say, look, we're just trying to follow the law. The law tells us we have to give them notice of that, and so that's what we did. But what does that do for their answer? Ask yourself, members of the jury, compared to the rest of the answers that she wasn't prepared for, which one's more truthful? And you can use that in your closing address later on. Okay, number 4 is prepping your client to testify. Educate your client about the twin myths. Make sure he's mindful. I say he in this because it's probably mostly men who are not mindful of it. Make sure he's mindful of how certain things are perceived. Okay, you have to make sure that they understand and that they are educated about this, because they need to understand why our law is like this. They need to be educated about beliefs and improper understanding of these dynamics, because it is a problem. And quite frankly, if they don't have that understanding and they're engaging in that reasoning, it's obviously going to be hugely detrimental to their case. And it's not something that you want them to engage in. So you want to educate them. You want to take the time to sit down and educate them and get through to them. And if you need to, you got to get through to them. Discuss, when your client's giving you their version of events, discuss how they convey their information and versus what to say. You don't tell them what to say, but if they say blowjob, you tell them to say oral sex. You want them to present themselves in a respectful manner. You want them to present themselves in a way, and this goes for any case, but in sexual assault case specifically, you want them to testify in a way where they are respectful to the complainant, because it's a lot easier to just become defensive and disrespectful. And it's in chief, they're oftentimes, when you're asking questions, they're prepared, but it's the cross-examination where a Crown can get under their skin, and all of a sudden these negative characteristics start coming out. Myth-based reasoning starts to shine, or, language starts to get a little bit harsher because of that. So you want to prepare them. And that's why when I say educate them, it's not tell them what to say. You have to explain to them why any type of reasoning of this nature is just going to result in a conviction, and they have to block it out of their mind, and they have to get past it if they are that way. Some of them, and frankly, I find that with younger clients, they're a lot easier they have a better understanding of this. So I feel like with an older generation of clients, they have a lot more difficulty understanding this. You need to spend the time to educate them. Right. And I'm not saying that they believe this. I just say that they present in a way that might lead a jury to think that they believe that. And that's what you're trying to avoid. So educate them and explain to them why saying things in a certain way could be problematic. Draft an opening address. And I say keep it short and to the point. And when I say that, it's thank the jury for their attention, explain that there are two sides to every story, especially in an intimate relationship. I would avoid any anticipated details that you expect to hear from your client, because if they don't come up, then it looks like you said something that never came up. So that's a problem. And oftentimes the client might tell you some details, and then when they're testifying, they're nervous or they forget it or it just doesn't come out. And it just looks like you've said something to the jury that never came out. Maybe, you don't want it to negatively impact your client's defense. Focus on legal issues. Is it a consent issue? Is it a mistaken belief in consent? Is it and it didn't happen? And you might always, when I say two sides to every story, that's important, because if it's a consent issue or if it's a mistaken belief in consent, especially, then you want to give your guy a little bit of a heads up. You want to say to the jury a little bit of a heads up that give him the benefit of the doubt here to what he understood at the time or what happened. If it's that it didn't happen, then what you want to get to is, why would they make this up, right? Your client's going to deny it, but why would they deny it? Why did the person make this up? So keep it short, keep it tight, and don't get into the weeds on the details. With respect to the closing address, I have a more comprehensive thing that I'll provide for everybody tomorrow through Maya. which goes through a lot of these points more fulsomely, because I noticed we only have a few minutes left before question and answer, but I'll just go through it. Keep it short. My rule of thumb is 1 hour for every month you're in court on a case. So if it's a 3-month trial, 3-hour closing, less than a month, less than an hour. It's a sexual assault case. If it's a 1 or 2 witness case, you don't need that much time. Some people like go through all the evidence or reasonable doubt or whatever. Don't do that. Do it, but keep it tight, right? Time yourself. What I've been doing recently is just recording my closing address. I write it out in the words that I intend to use precise language. I think that's super important, especially when you recount the evidence. If you're not recording the proceedings, you can apply to record the proceedings now. So I recommend people do that. But if you're not recording the proceedings, take detailed notes and use precise language, because if you say something wrong with respect to the evidence, that's going to blow up on you and a judge will jump down your throat and correct you in front of the jury, which is a problem. But what I like to do is I drafted out how I want to say it in terms of colloquial language and a speech, and then I record myself for time purposes, and I record to see how it sounds and if there's things that I don't like. And what I've noticed in doing that is it's really gotten rid of a lot of the repetitiveness. When your first draft, let's say you write it out, your first draft might be 20 pages long. By the end, you're down to 12 pages, because you don't realize how much you repeat. You don't realize how many times you might use a rhetorical question, or how many times you might use you might sound sarcastic in something. You want to change the words, right? Use words that you're comfortable with, but do that. It's a good practice. And then when you get your final version, you just listen to it. I just listen to it a few times so that I can remember it. And when I'm delivering it, yes, it's in front of me, and so I have that to rely on. But I've listened to it and I've pretty much memorized it, so I know what I'm going to say anyways, and I can just engage the jury. And it sounds like I'm just giving a speech rather than reading something. But in order to do that, you got to start working on it like throughout the course of the trial. You'll see in the materials that I send out, but what I like to do as a trick is I do my introduction even before I start the trial, so that's already kind of done. Reference to what the next point is: legal principles, the law. Well, my lights went off. There we go. Generic legal principles. You don't need to do that at the last day of your case. You can do that in advance, so that you have that done. Plus, you also have a starting point, and then you get into it. If your guy testifies or your client testifies, start with that. Comment on his testimony first, because you want it to be at the forefront. Address any issues. Don't shy away from any concerns with his testimony. Explain that if the accused testimony is accepted, that they should be acquitted, right? Then you move to all the gaps of the Crown's case and why they failed to prove beyond a reasonable doubt. I only do the 2 branches of WD. I never get into the middle branch, because I don't want to go there. It's either the accused or the Crown. The judge will give them that middle way out, right? So you can confirm the holes of the Crown's cases or their reasonable doubt on their own, but you implore the jury to accept your client's testimony and acquit them. Leave the impression with the jury that they can acquit the client without having him. They could have acquitted him without having him testify, but he chose to testify to give them the truth, and he should be acquitted because of that. And that's it. You give them 2 options, 2 opposing sides, right? Let them wrestle with it, mine and the Crown's, and then the judge will give them their 3rd route to an acquittal, which you hope that's what breaks the tie between anybody who's leaning Crown and leaning to defense. You hope that the judge says, well, even if you don't accept the accused testimony, but you're struggling with it, and it's left you in reasonable doubt, you should still acquit him. That's why I don't address the 2nd branch of WD. I leave that at all times. So basically, it's 7:59. I got it all in the hour. I know I went fast, but let's go to question and answer. Question in the room.
Do you have any tips for pre-charge conferences?
Tips for pre-charge conferences is the question. In sexual assault cases, they're pretty straightforward, I find. It depends on what issues arise in your case. I typically look, once I do my closing address, I know the charge of the charge to the jury is an important step, but like you're so drained by that point, you get the judge gives you the charge. I look for things that might jump out at you in terms of, are you rolling up a charge? Is this a consent and a mistaken belief in consent? Are those both available to your client? If they're both available to your client, even though your client, testified that there was consent, if the facts lend themselves to a mistaken belief in consent as well, you might want to say to the judge, look, the jury should have to consider that aspect. Well, but you didn't go to the jury with that. I know I didn't go to the jury with that, but it was available to them on the evidence that came out and through my cross-examination. So you want to make sure that you've covered every point that's there, and that all the legal issues are front and center for the judge to consider. And they're not usually that long in sexual assault cases if it's just a 2-witness case. So we can you're gonna have to figure it out as you go along and what the judge is given to you. Question in the room?
What would you do if the judge forgot to remind the jury or tell the jury about the second branch of WD?
No, the judge cannot forget to tell the jury about if that happens. I mean, you're going to get a copy of the charge in advance. Usually they break down WD. It's straight out of like the manuals. If they forget to tell them about the second branch of WD, you go and you insist on them telling them about the second branch of WD. And good Crown attorneys will also support that, because good Crown attorneys they don't want that type of ground of appeal. The jury has to be left to understand that, even if they don't believe the accused, they can still acquit if they're left in reasonable doubt by their evidence. So you want to make sure, but that's just not something that I like to say to the jury. Be left in reasonable doubt by my client's evidence, because it's a little cute for my liking. Anybody else? Any other questions?
Yes. Hello, Marco.
Sam in the room.
So you explained very well, like the question I had with the prior transcripts.
Mm-hmm.
And so I think like you mostly answered it, because I think the goal is to get the Crown to the goal is, I think, to get the Crown to do like an agreed statement of fact.
Yep.
But I had this happen with a judge alone trial, and it was with a child witness. So I mean, obviously there's different particularities that occur with them, but it's a situation where they're denying something that in the copy of the transcript is blatantly there. Mm-hmm. And so when you have a difficult Crown, this is obviously the minority, but most Crowns will sort of like do that agreed statement of fact. But say you have a difficult Crown and you're not putting the copy to the witness necessarily, like how do you, probably I would ask the jury to be excused and take that up with the judge. But I was just wondering if you had any input on like that specific instance.
If the witness is denying something that's right in the transcript, you take them to the transcript.
Okay.
The question was, what if they deny something that's in the transcript? You take them to the transcript and you say, again, we'll go with the blue shirt. I mean, I'm going to suggest to you that you were wearing a blue shirt that day. No, that's not true. Well, do you agree with me that you told the police that you were wearing a blue shirt that day? No, I disagree with that. Turn to page 29, please, of the transcript. I'm going to read the following questions and answers. You read the questions, you read the answers, and then you ask them, you were under oath at that time, you were telling the truth at that time. They all say, yes, I was. And you agree with me that you told them there's a blue shirt. If they still deny it in the face of what's on the transcript, the next thing, if you read the textbooks, they'll say, do you take an issue with how the transcript is typed? Right. And they might say, yeah, I never said that. I don't know why it's in the transcript. Do you want to watch the video? You can, if they want to take that step, then you can watch the video. If the Crown's going to make you do all that, then you just got to take the steps and do it. Right. Because if you ask the jury to be excused, you'll say, well, you know what, Your Honor, I'm going to have to play the video. Let's say I'll ask the jury to be excused. You say, I'm going to have to play the video for this witness unless my friend's willing to agree. Oh, no, I'm not willing to agree to that. Fine.
Okay. I like the video idea. But what if there's no video?
Fine. But if there's a transcript, there's something, right?
Yeah.
Right. If they didn't, if there's a will say, if whatever's there on the paper, if they deny what's on the paper, then you got to call the person who, like, if it's a police officer who wrote it down, then you're going to have to call the police officer. Like, this happened to me in a case last week where, in the occurrence report, it said the person told the police that they were living in another house since January. She goes, no, I never said that. Fine, you never said that. Now it's up to me. Do I want to prove that statement false? I got to call a police officer to come to court who wrote that down. Why would you write that down? Well, that's what she reported to me.
Oh, maybe you could use that to further push the Crown for being difficult.
Right.
Yeah. Okay.
They don't want to police the police officer, but you got to play. You got to, if they're like in that case, I did every occurrence report detail. She kept denying that she said that to the police and that the police were just wrong. So in a jury trial, if the police are wrong five different things that they details in these occurrence reports, it looks bad. That it looks like she's hiding something, because okay, they might be wrong on one detail, but 5 different details. Every time I put in the police report, it just says this. Well, I never said that. So now what? I'm gonna have to line up all these police officers, which I would if I had to, or the Crown might say, no, they wrote it here because it was reported, and that's it.
And when you said you had, like, I really like the idea of blocking out like the excerpts. Can you put those in as exhibits then? Like, if you want to file that,
they have to be, yes.
Okay, rather than calling like an officer or something, you just feel like, I want to file this as part of like.
Yeah. So the way you would do it is you if there's a phone record, right? We're talking about the exhibits and the blacking out. If there's a phone record, you'll say, ma'am, do you recognize that phone number? Yes, that's your phone number, right? That's your name. This is the date. You go through it that way. And this is what you texted. I had a great time last night. Thanks for everything. And the answer was, can't wait to see you again. You recall sending that message? Yeah, I remember sending that message. It's all blacked out, screened out. And then you say, Your Honor, this would be the next exhibit. And it's text message from so-and-so to so-and-so, whatever date, and they adopted it. If they say, no, I never sent that message, then you're going to have to prove the message. Where did it come from? You could prove it through your client. Your client could say, yeah, this was on my phone. Or the police, you can call a police officer to say, we extracted the accused cell phone. This message was there, etc. It's from this number, it's from whatever. Question online. Any specific tips cross-examining an expert's forensic, like a sexual assault forensic nurse in front of a jury? That's a good question, Rebecca. It's from Rebecca Gill. That's a good question. It all depends on what evidence, I want to get from them. Sometimes those witnesses are called from a purely medical perspective. Sometimes they are called because, well, that's why the Crown calls them. And then from the defense perspective, you can maybe get other stuff from their report. Like, what did the complainant report to them at that time? Did they report that they were, digitally penetrated, but then when in the police station, they never reported that? Or you might find out some little details in those statements that they give to the nurse when they're there, because the nurses ask a lot of questions about how things occurred, or, parts of the body that were touched, etc. And if they've provided those details to the nurse versus what they said to the police, that could be useful in creating like inconsistencies between their version of events. So you want to look for that stuff. But from a purely technical perspective, unless there is something that's there for you from an expert perspective, you want to challenge the nurse's qualifications, or you want to challenge what the nurse did. I mean, I don't usually go there unless it's an issue in the trial. So it might be a little more specific to the issue. I hope that answers your question. I don't really have any tips unless it's specific to an issue. Somebody wrote, hello, Marco. Hello. Ms. Kamara, is there a question, or Mr. Kamara?
Yes, I have a question. I was just writing it down.
Any other questions?
Can you hear me? Hello?
I can hear you.
I think Marco cannot hear me. I'll just try to write down my question.
If there's no other questions, I'll just end off by saying,
okay,
don't be afraid to elect jury trials. I keep saying this over and over, but I just feel that we're being bullied out of them. I feel like nobody wants us to do them because they take up time, and they are not, judges want control over the case, and they don't have control in jury matters. Take the time put in the work, do the jury trials when you can, because common sense prevails oftentimes, and a lot of these cases are common sense cases. And even the sensational ones, like for instance, the one that was last year with the Headley guy, he got acquitted of a charge when everybody in the media was already prepared to convict him, and he got convicted of arguably the more difficult charge. So that tells you something. It tells you that people are out there. They are considering, the juries are considering the information. They are considering, and they're applying common sense. Judges are, in some cases, they go out of their way to believe the complainant sometimes, especially if your client has, a bad history or something to that effect. Ms. Kamara, Mr. Kamara, whoever that is, you can email. Just ask. You can type the question here if you want. Yeah, we can't hear you. Is there a way we can unmute?
I think that they were trying to unmute earlier, and it's the audio that's not working for whatever reason.
If you want to ask your question in the session, we do have a few more minutes.
Maybe while we're waiting for that, one final thing.
Sure.
We had a panel at one of the CLA law conferences, I believe it was last year. And I guess just in terms of like the law right now with child witness credibility, they were like, take a jury. What's your view on the child sex offenses?
Yeah, I it's the same for me. I mean, I think that obviously your approach with cross-examining child witnesses is completely different than with adult witnesses for obvious reasons. And I think you get a lot further on reliability points with child witnesses. You can take I don't think that there's a hard and fast rule. I think it's on a case-by-case basis. But, where you really run into issues is if there's a child witness who's young and could not have possibly made this up, you run into, difficulty, because it's like they don't have that understanding of something. But if they are, a little more mature and, maybe 8 to 10, 8 and above, under 8 years old, they could be a little bit more believable simply because they might not have that understanding that the general public would not have understood. But I think that, if a jury is going to convict your client based on a child witness, I think a judge would too. I don't think a judge is going to say, well, we're going to let this pedophile go free, based on unreliable evidence. The judge can find their way there. So it depends on the case. Obviously, I'm always a proponent for the harder the case is, take a jury, because, if your case is difficult, you want to put the Crown to task. And to put them to task means they have to convince 12 people versus convincing just one. And the one person who's seen a lot, a judge who's seen a lot and has experience, they can, separate things very easily. Whereas a jury is 12 people and you don't know what you're going to get, and it makes it a little bit harder for the Crown to prove their case. So I think Ms. Kamara is going to have to email me privately. I don't think that anything's coming through. And unless there, sure.
Quick question.
One more question in the room.
Recording. To ask, what do you record with?
You can record with any device, any recording device. You just have to apply to the court.
You have to do it ahead of time, or you can just ask.
No, I'll tell you right now. There is a particular section. There might be a specific section in for the provincial court rules and the superior court rules. But hang on. So in the OCJ, it's subsection 3 of the Ontario Court of Justice Practice Directive Protocol regarding the use of electronic communication devices in court proceedings. So you can just ask the judge for permission to record the proceedings pursuant to that section. Okay. In the SCJ, it is for note-taking purposes. It's always for note-taking purposes. You can't disseminate it. And under the Superior Court of Justice Practice Direction 100 sub V of the use of electronic devices in courtroom. I just put that on the record, and the judge basically lets you record it, and then you can record it using your phone, your computer. Some people have programs on their computer where they type and it records, and then you just get so that your notes can go back and you can kind of hear. Any type of device, that recording device, or if you just have a recorder that you place close to the witness box or whatever.
And you just do that like at the beginning of the trial.
That's right. Yeah, I just do it at the outset of the trial. It's only for note taking purposes, and yeah, judges don't even know about it sometimes, and you just have to bring the application to do it. But yeah, take advantage of that because it makes your life a lot easier, and you don't have to order digital audio recordings, etc. Okay, guys, I think that's it. Thank you everybody for coming. We lost a lot of people to the Blue Jays playoff game tonight, but this is being recorded, so I guess people can take a look at it at a later time. So thank you for having me, and I look forward to coming back later on and do something else at another time. Thanks, guys.
Thanks for the